most people would agree that climate change is indeed an existential crisis. In my view, it's therefore essential that all the policies that we have, including competition law, play a part, even if it is a subsidiary part. As Commissioner Vestager has said on more than one occasion now, everyone is called upon to make our contribution to the necessary change, including enforcers. Of course, in many cases, regulation is the appropriate answer, perhaps in most cases. In many cases, individual businesses can do things on their own. Some businesses will be able to gain a competitive advantage by adopting a more sustainable product. But unfortunately, in many cases, it's necessary for businesses to cooperate, to work together. That may be simply to achieve the necessary scale to move the dial in the face of the crisis that we face, or it may be necessary to overcome what's called the first mover disadvantage. If I'm the only one incurring some extra costs to make a greener product, I may not sell any, I have a competitive disadvantage. But unfortunately, there seems to be growing consensus that fear of competition law is standing in the way of such vital collaborative action. A recent survey showed that some 60% of businesses said they had shied away from collaborating with competitors for fear of competition law. And I would commend a paper by Unilever in their submission to the European Commission in the context of the horizontal guidelines, which sets out dozens of examples of just the sort of thing that needs to happen, that should happen, but might not happen if they are over afraid of competition law. But need competition law be an obstacle? I've been writing and speaking and looking at this for a year or so, and at the end of my presentation you'll see some references to some of the papers that I and indeed others have written. But the short answer to my question is competition law need not be part of the problem. We already have some pretty good legal tools. For example, the constitutional provisions of the European treaties and the competition provisions themselves, both at the European and the national level. And my plea is that we should get on and use these, use them properly, rather than get overlost in abstract and imported concepts like consumer welfare, public interest, non-economic factors, and a whole host of other things that people seem to be tying themselves in knots with. Now, I'm not going to dwell unduly on the letter of the law, but I would like to mention Article 11 of the Treaty on the Functioning of the European Union. This says that environmental protection requirements must be integrated into the definition and interpretation of the Union policies and activities, in particular with a view to promoting sustainable development. Now, where does it say, except when implementing competition policy? We must take into account environmental protection when applying all the competition provisions. In my paper, particularly that in the Journal of Antitrust Enforcement, I set out 5 ways in which I think agreements might escape the prohibition on anti-competitive agreements. Now, I'm not going to go into all those today. In fact, I'll focus just on one of them. I'll just identify them here. First of all, in most instances, there is no restriction of competition or no appreciable restriction of competition at all. Secondly is what I call the Albany route, that is leveraging of the Albany judgment of the Court of Justice. Happy to talk about that if people want me to. Thirdly, there's the so-called ancillary restraints and objective necessity doctrine. Fourthly, if set up as a standardization agreement, that might not be sort of good chance it won't be caught by competition law. And fifthly, if caught by the prohibition of Article 1011, it might be exempt under Article 1013. And I want to say a few words about that provision. As I suspect most people on this call know, for an agreement to be exempt, each of 4 conditions must be met. There must be no elimination of competition, rarely going to be relevant. The restrictions must be no more restrictive than necessary, very important, and that's why if a company could go it alone, you may not be able to justify collaborating or cooperating with a competitor. It's simply not necessary. But the first 2 conditions I do want to say a word about. The first condition is that the agreement must contribute to improving the production or distribution of goods or to promoting technical or economic progress. And I think people tend to make 2 mistakes when looking at this, and I hold up my hand, I've made these mistakes myself. First, people tend to focus on the economic element, which is very important, but then they get lost. How on earth can we tie in all these non-economic factors into the economics of it? Well, you don't need to, not in many cases anyway. What about the economic bit is only one of 4 limbs to that first condition, improving production. How about agreements for users to use agreements to use fewer resources, improving distribution. How about sharing distribution logistics on occasions, promoting technical progress, developing new greener products? And the second mistake that people make is to say, well, they summarize the exemption thing by saying it's about the pro-competitive factors outweighing the anti-competitive factors. Well, no, it's not. I've used that expression many times in my past, and I feel guilty for it now. It's a convenient but lazy shorthand. One should look at the actual wording of the law rather than glib shorthands like that. And the second provision is that consumers, quite rightly, must get a fair share of the resulting benefits. Those are the benefits to which I've just referred. Note, first of all, it's a fair share of the resulting benefit. It's not just about lower prices. The most difficult question is probably which consumers. And there are suggestions at times from the European Commission that it must be just the consumers who buy the particular widgets in question. But that can't be right, because many benefits are near to a wider group of people, not least environmental benefits, and that's been recognised by the Commission's own guidelines and in cases such as the washing machine or CSED case. But I do recognise this is a very difficult area, and we need a constructive dialogue. Indeed, after discussions with senior officials at the European Commission, I amended substantially the first draft of my own paper, and there's now 6 or 7 pages on this area, and trying to set out some constructive proposals. And I had mentioned that the Dutch paper to which Sally referred also sets out some sensible and ideas for discussion. But what I would say is that it's essential that we give proper weight to what really matters. To what weight do we put on something being 1 penny cheaper, perhaps a product we don't even really need? And what weight do we give to having clean air to breathe, or passing on a viable planet to our successors? Unless we're careful, we'll ask the right questions but get the wrong answers. So my conclusion is, collaboration for sustainability purposes is possible under the law as it stands. But sometimes people say to me, yes, but it's all too difficult, isn't it? Well, if it is difficult, we must apply the law. And we should focus surely on what is important rather than what's easy. If we don't, competition law risks being irrelevant, as many people have suggested has been the case with US antitrust in recent years. And be under no illusion, the narrow approach is not easy. Believe me, if you've been faced with 200 pages of conflicting econometric evidence in court, you know a narrow conventional approach is not easy. Balancing difficult factors is what competition authorities and courts naturally do, and they're increasingly well equipped to do that, given the diversity of skills which they have brought in. And this is an economic approach. In some ways, it's a more economic approach, not a less economic approach. Taking account of externalities or calculating true prices, the Dutch paper again has an attempt at some interesting comments on that, is complex. And we can make use of emerging techniques for environmental economics. But having said that, we should never lose sight of the need to make value judgments. It's not all about numbers. Finally, on this point, people say, but isn't it a slippery slope? What about other things, important as they are? And I know David will talk about some of these. But I'd make 2 points. One, if we're going to single out any one thing, climate change is the one we need to single out, important as other things are. It's the existential threat. And the other issues, important as I say, social concerns, should stand or fall on their own merits, but do not let any difficulties there undermine the imperative of finding a way to enable business to collaborate where necessary to fight climate change. So in conclusion, a narrow approach is not necessary and can be an obstacle to vital collaborative action. Ask yourself this question if you're involved with competition law. Are you happy with it? If competition law isn't condemning some nasty cartels, great. If it's enabling some good efficiency enhancing mergers to be approved, great. But if it's standing in a way of vital things which we need to do as a society, I personally am not comfortable being a competition lawyer. There's much, as I say, we can do without changing the law. We need to revisit the law and economics. But I'm not naive enough to suggest we can just sit back and say, well, there's no problem. Changes are needed and changes are afoot. In my paper, I've set out half a dozen or more proposals for action. Signal out perhaps 2 or 3 of those. One, we need more positive statements from the competition authorities. Yes, they need to tell business all the things they can't do with their competitors, very important. But also they need to hear more positive messages to what they can do. This was certainly something which I emphasised when I was involved with competition compliance. And increasingly we're seeing people like Commissioner Vestager saying, well, bring forward cases to you and we can give a positive steer. That's great, that's a development. Secondly, we need to update the guidance and notices and guidance on the authorities' priorities. And we're seeing that. The Commission is revisiting its horizontal, is consulting on its horizontal guidelines. They are looking to bring in a consultation on sustainability and competition law. We've seen the Dutch paper, we've got the Greek paper, and the UK has made climate change a strategic priority for the first time ever in its annual plan. They talk of supporting the transition to a low carbon economy. And thirdly and finally, just to single out, I think we can learn some lessons from the COVID-19 crisis. If the authorities can be flexible in their thinking and helpful in relation to what I hope is a short-term crisis, the COVID-19 crisis, then they can apply some of that flexibility to the longer-term existential crisis of climate change. So in conclusion, 3 points. I believe we have the legal tools to take sustainability into account in competition law. Competition law need not be a barrier to vital action to tackle climate change. And my paper sets out a number of practical proposals to make it clearer, to make this clearer and to make it easier for business, including members here, for business to play its part without fear of competition law. Thank you.